Hey everybody, this is Ryan McClanahan with historythroughcards.com. Hope you're all doing very well today. So a while ago I was listening to a video from Raul from AIH Sports, and he had mentioned the Topps Fanatics, what their terms of service was. I got really kind of curious about this because apparently he had gotten something from Sports Collectors Daily and posted it on his video, and then I guess just kind of backtracking here, it was originally on Dan the Cardman's channel on his video. He's actually really good. I like Dan the Cardman, and I like Raul too. I've been on Raul's channel a couple of times. Both of them have great content as far as I'm concerned. Today, though, I thought I would actually go and discuss a little bit about the terms and conditions of both Tops and Fanatics on their website and what they post because quite frankly, I'm going to have a different view, a different take than both of these gentlemen and even Rich Mueller. And I'm a little concerned, to tell you the truth. Not just the fact that it might be really kind of a violation of the Clayton Act from 1914, but that there's something in the arbitration portion of Tops or Fanatics, if you will, because Fanatics bought Tops on January 3rd of 2022 for $500 million. What is acceptable on one platform, it also goes for the other because they're essentially now the same company, or one company is owned by the other. So it's it's cross-platform, so it applies to both. You can say whatever you want about that, whether or not it's a monopoly or it's starting out to. I'll actually give you guys my take at the end, whether or not I think that it's a monopoly. Um, there's something to be said about a lot of the stuff, in fact, that is not very good, I think, for the small business owner or the LCS, the local card shop. This is actually a contentious issue, as it turns out. A lot of people think that the card shops need to be reined in, and other people say that it's a monopoly and it's hurting small business. Just going through the terms and conditions here, I did find again the arbitration section, and that is actually section 22. It's really incredible what's going on here in the hobby. You know, looking back at my own hobby career, if you will, the hobby has changed so much since I first got into what was then the modern hobby back in the 1980s. I actually switched over to vintage in 1994. So this doesn't really apply to me. I don't really collect modern cards per se. I do have a few here and then. For the most part, I want to say like 95% of my collection is vintage. So I'm really kind of looking at this as a sideline reporter, if you will, someone who really doesn't have any skin in the game, except that this actually it could maybe someday affect how people buy and sell vintage at card shops. The one thing that eBay is really good at is that when you're looking for a card, it's there, and it could be from anywhere in the United States, or it could be from overseas. So you have a better chance of finding what you're looking for on eBay compared to say a local card shop. Now, card shops kind of did die out, or became an endangered species, if you will, because of eBay. Um, and it's just a progression of technology, really. I mean, it's all we're looking at. You could go back into the days of the early days of the hobby, if you will, probably about 1948. Goody Goldfaden, I believe that's his last name, Goldfaden. He was the first person to start a card shop. Now, it wasn't a true card shop that we know of today. He sold a lot of like memorabilia and mostly magazines, but he did have cards as well. And then I want to say you had the distributors in the 1950s with Woody Gelman or Gelman. I always screw that up. You guys know that. And his father-in-law, Sam Rosen. Is that it? They had a mail order business, and that's mostly how you got your cards in the 1950s, 60s, and 70s and 80s. And in fact, I started collecting vintage cards through mail order businesses. Mike Wheat, in fact, and Wayne Varner's Shoebox Cards were the two guys that I went to for vintage when I was a young collector, a novice, if you will. And so they were great, but again, the internet came along, and the internet really is kind of like only 25 years old. It's the internet that we know of today, and so for the most part, that's really kind of like when the card shops started to die off was when eBay showed up in I think about 1997, 1998 or so. This is Fanatics Terms and Conditions, updated on August 11th, 2021. Acceptance of terms of use. By accessing and using the properties, you agree that you have read, understand, and agree to be legally bound by these terms of use. If you do not agree to be bound by these terms of use, you may not access or use the properties. These terms of use may be prospectively changed, modified, or altered by us in our sole discretion at any time without prior notice. If we materially change the terms of use, we will notify you through a notice updated terms of use of properties or by email sent to the email address specified in your account if any prior to or upon the changes becoming effective. Accordingly, when you access or use the properties, you should check the date of the terms of use and be aware of any changes since the last version. Your continued use of the properties following the posting of any changes to these terms of use means that you accept such changes. Your access to and use of the properties will be governed by the terms of use in effect at the time of such access or use. This is section 22, arbitration, no class action. Please read this section carefully. It may significantly affect your legal rights, including your right to file a lawsuit in court. Use or accessing the properties or offers constitutes your acceptance of this arbitration provision. As a condition of using the properties, you and we agree that any and all disputes, claims, and causes of action, collectively, quote, claims arising out of or connected with the properties, except for small claims court claims, if applicable, shall be resolved exclusively by binding arbitration under the rules of the American Arbitration Association or AAA, including the supplementary procedures for consumer-related disputes. For a full and final settlement of such claim, applying the Federal Arbitration Act and other federal arbitration laws. You understand and agree that you are waiving your right to sue or go to court to assert or defend your rights under this contract. You and we also agree that A. Any claims will be resolved individually, not as a plaintiff or a class representative, member of, otherwise on behalf of others in any proposed class, collective, or representative proceeding and not through any class action. B. If a claim proceeds in court anyway, we both waive any right to a jury trial. And C. Either you or we may seek a court injunction regarding intellectual property infringement Arbitration does not involve a judge or jury. Although court review of an arbitration award may be limited, an arbitrator is empowered to award the same damages and relief as a court, including injunctive relief or statutory damages. Notwithstanding the foregoing, either party may seek temporary or emergency equitable relief to enforce its rights in any court of competent jurisdiction. You may seek arbitration of a claim by contacting our registered agent at Corporation Service Company, 1201 Hayes Street, Tallahassee, Florida, 32301. The arbitration may be conducted via telephone, written submissions, or in person in a mutually agreed location. Payment of all filing, administration, arbiter, and/or mediator fees will be governed by the AAA rules. The AAA rules are available at www.adr.org or call 800-778-7879 toll free for instructions on how to obtain a copy, unless the AAA arbitrator determines that your claim was frivolous. We will 1. Reimburse you for the fees paid by you, and 2. Will not seek reimbursement from you for our attorney's fees and costs associated with the arbitration. You and we further agree that an award and any judgment confirming it only applies to the arbitration in which it was awarded and cannot be used in any other proceeding except to enforce the award itself, and any post-arbitration action seeking to enforce an arbitration award or action seeking equitable or injunctive relief shall be brought exclusively in the courts of the state of Delaware or the United States District Court for the District of Delaware. For any claims that are not subject to arbitration, if any, A. The exclusive jurisdiction and venue for proceedings involving claims shall be the courts of competent jurisdiction sitting within the state of Delaware, and the parties hereby waive any argument that such court does not have personal jurisdiction or that the forum is not appropriate or convenient. B. You and we waive any and all rights to trial by jury with respect to any claims. Okay, so let's break this down, shall we? First, I've actually been through arbitration a couple of times, and I do have a really in-depth knowledge about the proceedings themselves and what goes on behind the closed doors, if you will, of arbitration and the awards and all that. And I'm going to break that down as well. I've also been to federal court and state court as well, so I have a long and drawn out history, if you will, in all three of these areas. And so I'm going to kind of tell you first off, why would Topps or Fanatics want to go to arbitration instead of a court? I believe, in fact, that it actually stems from Judge Clarence Newcomer's decision in 1980, which declared that Topps was a monopoly and broke it up. It allowed for Flair and Don Russ to enter in to the sports card market, but afterwards, all three of these companies, especially Flair and Topps, were still in court. They would go back and forth, and all the lawyers' fees and the bills, they started to pile up. So it was Arthur Shorn of Topps who said, I believe in a 2013 interview, Topps had so much debt that they couldn't really pay their payroll. They were about 2 weeks away from really, I think, going bankrupt or not being able to pay their employees. And I think this is really why they are now wanting to go to arbitration. For a lot of people, arbitration is said to be more cheaper than going to court and is more cost effective. Doesn't take as long as a court case would. And I have found that not to be true. It could be true in certain circumstances, but I was in arbitration for 5 years in one case. And so there's a lot of pros and cons. I think what I just said was one of the quote unquote pros of going to arbitration. I think as I go through this, the cons are going to outweigh the pros of going to arbitration. In any case, going through arbitration or a federal or state court is really stressful for a lot of people. Arbitration is not subject to the same rules of discovery. You're limited in the amount of documents that are requested, whereas in a court, the judge can rule that the other side has to furnish you with as many documents as your lawyer requests. And this is called discovery. And the rule of discovery obviously is much different in arbitration. Arbitration, you still can get discovery, but it's just much smaller. Under Rule 26 of the Federal Rules of Civil Procedure, that you can get any document in a civil court case if you need to. But again, like that's not really the case with arbitration. In the federal rules of civil procedure, you also have Rule 37, which is a failure to disclose information required in Rule 26. And a judge can issue a motion for a sanction to compel or dismiss the case if he needs to compel the other side to get information. Then, and if they don't do that, then the judge can he can levy penalties on the other side, up into including again a dismissal of the case or heavy fines on the other side. So it's generally a good idea to follow the rules here. And so arbitration cases are non-refundable, whereas a regular case you can collect attorney's fees, and it seldom can be appealed as well, where you have the appellate court in a civil case. Typically, it is a business that decides the person who arbitrates the case or decides the case, and generally it is not in favor of the employee or the customer. And I looked up some percentages on this, which kind of back this up. So in a court case, there was a few studies that I looked at. The first was that in terms of win ratios, that was 30%. Another one was 43%, and the highest was 60%. And one third of those involved were actually contractual disputes, which was 66%, while the other was, I believe, 53%, again, were tort cases. In arbitration, the win rate was 42%, though I did see another percentage that was 36%, and then 11%, which was in Great Britain. Now, Great Britain, they do have separate laws from the United States, so that very well could be the case in Great Britain. If that is the case, I am never moving to Britain, and I'm never going to get a job there. But again, it's a different country altogether with different rules and laws. One of the biggest reasons for this really is that company chooses basically who the arbitrator is. I've heard that both sides kind of like agree to the arbitrator. I'm not entirely sure how true that is. I've been actually really fortunate in arbitration. As I say, arbitration is something that you do not want to go into without a lawyer, and same with court too. Lincoln once said that anyone who represents themselves in court has a fool for a client, and that is really true. I've only won one federal court case representing myself, but that was because I knew exactly what I was doing, and I had all the documentation, and I could prove beyond a shadow of a doubt what had happened, and the judge ruled in my favor. And so that is very, very unlikely that the majority of people are going to win by having themselves represented or representing themselves in a courtroom. I don't suggest doing that at all. I just got lucky. I had everything documented. And here's the other thing in a civil case or even in arbitration, you could think that you're 100% right and have everything documented, and you could have all the right witnesses and everything could line up, and the judge or the arbitrator could basically say, nope, sorry. Especially when it comes to a court case or all these procedures and civil procedures of how to do things correctly, the way that the court system is set up. A lot of people now are saying that we have a dual system of justice. I'm not going to go there, but it's looking in that direction to be correct, and it's a political thing. But these things kind of spill out into other areas, so it's one thing that you have to kind of like keep an eye out on. We really need to be a nation of laws and not a nation of men. Now, I know that I try not to get political, especially current politics suck. The only time I really get into politics or the laws or anything like that is when I'm discussing vintage cases, vintage sports cards. So a lot of times we don't realize just how much the laws and the statutes have played into the hobby and the distribution of our cards, the production of our sports cards. And I do get into a lot of this in my writing. In fact, and I know again, people are really sick of politics, and I am too. I very rarely do I ever discuss politics, current or like otherwise, unless it has to do with the distribution or the setup of our sports cards and how things came to be. Again, if it was up to me, I would get rid of political parties altogether. I don't like them. I try to get away from that stuff by getting into sports cards and listening to music and watching really bad movies. So, anyway, let's get back to this. One of the reasons why a lot of people lose, or most people seem to lose at arbitration, is because the companies themselves are the ones that pick the arbitrator. And unfortunately, I think what happens is that the arbitrators they start to have a reputation, and if their reputation is for uh, siding with the victim, if you will, the customer or the employee, that means that they're not going to be chosen by a company, or in this case, Tops or Fanatics, and they might go out of business. So that's really why I think a lot of people don't win at arbitration, and it's different when you have a person going to court. So with a court, a lot of people say the win rate of a trial lawyer is very important, and I don't think that's the case at all. You have like was it the Rainmaker? So that's kind of like where I kind of stand on this. Great movie, by the way. I really enjoy it. I think it's John Grisham who did that movie. In any event, um, what a win really constitutes is several things. First, the judge, the jury, it's the location, the complexity of the case, whether or not either the jury or the judge understands what is going on in the case, what the facts are. And in a lot of cases, you can set the location depending on, say, if you committed a crime. Uh, if you did, I won't tell anybody, don't worry. The location really depends on whether or not you committed the crime in a state or a district or whatever. But in an arbitration, you don't get to have the set the setting, if you will. The other thing with arbitration, which I really don't like, is that you have basically limited facts. You have no chance to really do cross-examination of witnesses because I think the majority of arbitration cases, it's document-based case, and so there aren't a lot of witnesses, and I don't think they have to again they have to produce witnesses. Now I've heard that arbitrators can actually have the other side furnish a witness and cross-examine, but I've I've seen otherwise directly that you have witnesses that will refuse to answer questions. So like, I don't know, I have no idea, and really nothing happens. Even if you lie, so you're under oath when you are under arbitration, and I've seen a lot of people lie under oath at arbitration, and um, they there's nothing really that happens to these people. They don't, unlike a court case, you don't go to jail for lying under oath. People obviously they do. I think the Duke lacrosse girl, she lied under oath and she did go to jail. Actually, that was a different case because she ended up killing somebody, acing them, I should say. But that's different. That's a regular court case. I'm talking about arbitration. Nobody goes to jail in arbitration. So um, maybe some people should. That's a different story for another time, though. This is, to me, very frightening because under the Sixth Amendment, you have the right to A, face your accuser directly. You have a right to a speedy and fair trial. And in this case with arbitration, you're forced. Fanatics is forcing you to go through arbitration, which means, again, you are signing away your civil liberties under the Sixth Amendment. I don't know how that's legal, but it is. And maybe someday it'll change. I don't mind arbitration per se as long as you understand the rules, the regulations, and maybe what the outcomes could be compared to a court. You should have the choice whether or not you go to arbitration or through a court case. It's up to it should be up to you. However, in this case, it is not up to you. You have no say whatsoever on when you do business with either Tops or Fanatics. So, again, this is a contract and you need to fully understand and comprehend what you are reading and signing off on when you agree to these terms and services and use of Fanatics and Topps website and doing business with this company. Again, you are abdicating your authority basically as a citizen of the United States and under the Constitution when you agree to arbitration. In most cases, again, there may be certain reasons why you'd want to go to arbitration, but again, as I said, if you do decide to go to arbitration, don't go alone. Go with a lawyer and I did look at a couple of lawyers' fees for specific arbitration lawyers, and it was anywhere from 175 an hour to $400 an hour. So, because arbitration is private and you're not going to know what the outcome is, and this is one of the reasons why small companies or really a lot of companies want to go through arbitration because it is private and because that information, unlike, say, a legal court case, is not privy to the American people. And that in itself is a huge red flag for me. If you do decide to go to arbitration, make sure that you do research on the arbitration lawyer and understand their fees first, and contact them and see what they say if they're going to pick up your case or not. Not all lawyers are going to want to pick up your case, and so uh, it is in your best interest to do as much research on this stuff before you actually decide to do this. Finally, on this, the financial and monetary awards through arbitration, they don't typically lead to a fair monetary outcome for customers or employees compared to a court. And for the most part, they will get 50% or less to what the employee or customer would be receiving through a trial, a jury trial. So keep that in mind as well. And again, if you do win a court case and trial, I guess you pay your lawyer one third, which is fine because again, these guys and girls, they're doing a lot of work behind the scenes that you might not be privy to or understand, and a lot of documents, and it's one third is not bad than no third. Okay, so just again, keep that in mind that these guys are doing a lot of work on your behalf, and again, and be respectful of that. So with all the arbitratable cases that have gone through Tops or Fanatics, we actually don't know what their one loss record is, if you will. Um, we also don't know just how many cases they've actually had through arbitration. It could be low, it could be high. We just don't know because, again, arbitration is a private affair, if you will. The awards and the outcomes. Usually the arbitrator will send that person a letter or a document stating what the findings were and what his decision was. And we typically don't have this kind of information to share. It's private. So unlike a court, you can't go and see any cases that have come before arbitration through Tops or Fanatics, unlike, say, Judge Clarence Newcomer's case in 1980, and a lot of the other cases like Judge Jerome Frank in 1953, or Judge Clarence White, I believe it's James White from the American Tobacco Company case in 1911. We have all that stuff, and so we know the exact outcome and what the decisions were and how they came to their decisions. But with arbitration, you don't have any of that stuff. So just to keep that in mind, that there's a reason why they'd probably want to keep this stuff private as possible, because again, it could be damaging to their brand. For me, one of the biggest concerns about arbitration is the fact that you are signing or agreeing to hand over your civil liberties to a company, um, and that just really doesn't fly well with me, particularly because once you give up your civil liberties, it is very difficult to get them back. A lot of times you have to fight very, very hard, and unfortunately, we've seen the outcome, particularly in World War II. And don't ever abdicate your authority as under the Constitution. It's something that our legislators do often, and it's really been disastrous for the American people. But again, it's one of the reasons why I don't like arbitration. And again, I do say, like, if you want to go to arbitration, do it, but just understand what the consequences of that action is. And in this case, you don't have much of a choice to go through arbitration because Tops and Fanatics is not giving you a choice, which is forced arbitration, and it's a lot different than basically regular arbitration that people can agree to. In any case, you should be able to come together and hash out your differences. But unfortunately, we live in a society now that is really more and more unable to do that. And so that is a huge cause of concern. And I would have thought too that one of the reasons why we have sport is pretty much to kind of hash out our grievances on a court or a ball field or something like that. And I think that actually may be why they invented chess as well. So you can hash out your grievances that way and not have to go through a war or a civil war and cause bloodshed. I think that's actually a better solution than anything that we do on the battlefield. I don't really like combat or war at all. Sometimes it's necessary, and sometimes you have to understand too that you might not want to go to war, but that doesn't mean that the other side agrees with you on that, and there may not be anything that you can do about it. And that could actually be in the case of Tops and Fanatics as well, or say the small business owners. Uh, they obviously, from what I'm hearing, they're not really agreeing to what the terms and conditions are. They don't like them, and they're now getting kind of vocal about it, which who knows what the true outcome is going to be with this. Now, I also want to read their indemnity clause, which is number 16. And I thought this was actually really interesting too, because I think it has a little bit to do with what I was talking about as to why uh, they wanted to go to arbitration instead of a regular court. Again, it's cheaper for fanatics and tops not to go to court and go through arbitration where they actually don't have to kind of provide a lot of information and they're really kind of unaccountable. And actually, in their clause number 16, indemnity, they kind of tell us this. So I'm going to read this. It says, you agree to defend, indemnify, and hold us, our subsidiaries, affiliates, suppliers, and licensors, and each of our respective officers, agents, partners, and employees, the fanatics parties, quote unquote, harmless from any loss, liability, claim, or demand, including reasonable attorney's fees, due to or arising out of 1, your use of the properties in violation of these terms of use and are arising from a breach of these terms of use, including, without limitation, any breach of your representations and warranties set and forth herein. 2. Allegation that any content or other material you have submitted or transmitted to the properties infringe, misappropriate, or otherwise violate the copyright, trademark, trade secret, or other rights of any party. 3. Your violation of applicable law. And 4. Your activities or omissions in connection with the properties. So again, that's really kind of interesting. I know it's boilerplate, and a lot of contracts actually have that in their contract. But in this case, uh, there was that section, I think it was section 13, that was shown in Raul's video and Dan the Cardman's video as well, that the fanatics or tops wants to have specific demands placed on the shop owners. Specifically, I think, if I can remember this correctly, they want a specific section devoted to Topps product in their shops. This is 13, and I haven't seen this anywhere, so you might want to like find out exactly where this is in their contract, but it says 13. Retailers shall, on a quarterly basis or at such other frequency as Topps may require, submit to Topps complete, accurate reports regarding total sales of Topps product, sales by channel, in-store, online, convention, customer type, retail, consumer, dealer, convention, etc., and social media metrics for all platforms, including, without limitation, Facebook, Instagram, Twitch, YouTube, TikTok, Twitter, whatnot, etc. Additionally, upon request, retailer shall participate Topps point of sale programs and in surveys distributed by Topps on topics such as overall operations information, e.g., overall sales number of employees, etc. What? That's just that's a bridge too far, man. That I'm I should say I'm shocked. I'm more disgusted, I think. Anyway, let's continue. Customer reactions to the products or product breaks, current views on the market and varying market dynamics, product or process feedback to improve the direct selling experience. For clarity, in no event would retailer provide Topps with any personally identifiable information regarding its customers, employees, or otherwise. Okay, so there's obviously some issues going on there. Beckett used to do this, in fact, but they did it in a way that was not hostile to the shop owner or the small business owner. And what they would do was um, give prizes to anyone who wanted to participate. Not everybody wanted to participate in Beckett in their pricing data, but what Beckett did, I think, was really kind of very harmless. What it seems here is not so harmless. There could actually be proprietary data or information that the small business owner or shop owner does not want to hand over to Topps. Now, this, in fact, is really concerning for me because it really, I think, has to do with the Clayton Act of 1914. And what the Clayton Act did was it shored up the Sherman Act of 1890. And I'm going to get into the Sherman Act in a little bit here. But the Clayton Act, there is a section in it, in Section 3, and it is exclusive dealing. And what that is it limits the use of certain types of contracts involving goods when the impact of these contracts may substantially lessen competition or create a monopoly. The requirements, contracts, and tying agreements, as well as is found in Section 3. And you could kind of say that Fanatics fits this definition of a monopoly. And not all monopolies take over businesses. In fact, there was a monopoly of, I believe it was Microsoft, that was broken up in 2001, and that was not really business. It was not brick and mortar, I should say. It was more, I think, having to do with licenses, and so that I think that case has a lot to say about what's going on today. It was 2001, and I really wasn't paying attention to what Microsoft or Apple was doing back then, or I think it was Bill Gates. I forget exactly, but in any event, I do seem to remember in my foggy haze that that did happen in 2001. There are actually several antitrust cases. I think one of the most recent was 2021, but they do happen. So it's not like monopolies aren't broken up today. They're just not broken up in the way they were when Teddy Roosevelt and William Howard Taft were running the country. Uh, in that case, I think William Howard Taft actually broke up more companies than his predecessor. And it was kind of funny because um, John Sherman, when he wrote most of this bill, the Sherman Act in 1890, and that was actually based on what some states were doing in like 1888, 1889. They had come up with some antitrust legislation themselves. I want to say Missouri may have been like one of the first states. I'll have to check my notes on that, but it came to a point where the federal government had to step in, and so John Sherman, being one of the leading financial guys in the country at the time, he was an Ohio senator, and his brother was John Tecumseh Sherman. So John Sherman actually has a card. It's really neat. It's on one of my bucket lists, right? So it's in the 1888 presidential possibilities set. I've been looking for a card of his forever, and those cards don't come along all that often in good or collectible condition. So I'm still searching. But um, John Sherman said when his Sherman Act was passed, overwhelmingly, by the way, I think there was only one person who voted against it. And he said that he thought it was a failure and that it wouldn't really lead to much. And at first, I think he was right. The government or the Supreme Court didn't really do a whole lot with it up until 1901 when Teddy Roosevelt dusted it off and kind of made it his own, if you will. And it was through that where he was able to go after a lot of monopolies. And again, one of the biggest ones for card collectors is the American Tobacco Company. And the other one is the Standard Oil Company. And they say that it was broken up on the same day. I'm not entirely sure if it was, but it was definitely the same year in 1911. Uh, what happened though was that I think in especially in the case of the American Tobacco Company was that something that Louis Brandeis had said before he was a Supreme Court justice and or associate justice, and what he said was that some monopolies are so complicated and their breakup is very difficult and that might actually cause more harm than good. So, in certain cases, monopolies have been allowed to stay in place just because they could cause more damage or more harm. Um, I think that there currently is a monopoly on information and technology in, say, Google and all the other platforms. In that case, it goes to the Federal Trade Commission. So there is an economic percentage or model, if you will, to determine whether or not a business is becoming a monopoly or is a monopoly, and that is called the, I'm probably going to screw this up, but let's just find out. We'll see. It is the Herfindahl Hirschman Index, and it tests for market consideration to determine whether a merger is presumptively anti-competitive. Okay, so there we go. The Clayton Act specifically, which is a very powerful tool, and it may be even more powerful than the Sherman Act, although the Sherman Act gets a lot more play, I think, than the Clayton Act for good reason, in fact. So within the Clayton Act, there is a section that specifically deals with mergers and acquisitions that substantially reduce competition. And I think that if the Federal Trade Commission were to actually go after Fanatics and or Tops, uh, that uh, they would look at what is in the Clayton Act and apply it to this company. Whether or not they will is anyone's guess. So within Tops and Fanatics contracts, both of them, they specifically state that you are prohibited from using the likeness of a sports player or a celebrity, and that is actually under the right of privacy. So what's really interesting about this in regards to the right of privacy is that you have several cases that directly influenced the hobby. And one of those is the 1941 Johnny Mize versus Gum Products Inc. case from Cambridge, Massachusetts. I did a pretty lengthy article on this case and other right of privacy cases in regards to the production of sports cards. And this one is probably one of the first of its kind in modern history, if you will. And uh, Mize argued that he did not sign off on a contract to have his likeness on a card, and he sued Gum Products Inc. And um, he lost his case. And the reason why he lost his case was because the judge at the time, he had two judges. The first judge continued, basically, he had a continuance. And one of the reasons why he wanted to hold off on the case and continue it for another date was because he wanted to find out the particulars of this. Did Johnny Myers actually sign off for his likeness to be included in a card? And he wanted to know too if Johnny Myers did actually have the right to privacy. And we don't know if Johnny Myers actually signed off on this, if he even knew that he had a card. He most likely did see his card on the 1941 double play, which is the reason why he ended up in court in Cambridge. I actually looked for the stenographer's notes on this case and any documentation I could, and I couldn't find any. I think it's lost. In fact, it's probably somewhere. It could be somewhere, but I don't know where it is. In fact, nobody else knows where it is either. Johnny Mize lost his case because the second judge said that he was an entertainer and didn't have the right to privacy. And this was actually true with movie stars as well, not just ball players. So you can really follow the dots here with Tops and Fanatics in their terms of service, the right of privacy. Specifically, I think it says any images that include the name, image, again, or likeness of any celebrity, public figure, or individual who has not authorized the use of his or her name or image or likeness. Um, you can't do that with this company. I'm not disagreeing with this at all. I would not like it if my name or image or likeness was used for advertising purposes without my knowledge. And I think that's where Johnny Mize actually had a good point. But that actually goes back to the 1902 Abigail Robertson versus Rochester Folding Box Company. And in that case, Abigail Robertson was they say, a teenager at the time, and her photo was taken. She thought it was taken for one purpose, and it ended up actually being for an advertising campaign through Rochester Folding Box Company. She sued in, I think, 1900, and in 1902, they came out with the judgment. And at first, that judgment was for the plaintiff, for her, that the Rochester Folding Box Company shouldn't have violated her right of privacy. But it was overturned in the appellate court. And one of the reasons why it was overturned is because the technology at the time was so new that really, I think society was having a very difficult time with this, deciding whether or not it was a good thing or if it's a bad thing. Obviously, it's kind of like the internet today. I mean, the internet is great, but it can be used for an awful lot of bad things. It just depends on how you view it and how you um, behave on it. And same thing with photography as well. Again, she lost her case, but in 1903. New York had their own privacy statute because of the Rochester Folding Box Company case, or the Abigail Robertson case. And so, through the statute, what ended up happening was that the American Lithograph Company, when they were commissioned by the American Tobacco Company to issue the T206 set, the first thing that they had to do was have the sports writers in each city go to the ball clubs and have the players sign a contract. And we know this because we have one of those contracts, or one of the letters from Neil, for Neil Ball. He had to sign off on this, that it was okay to have his likeness on a baseball card, and that each uh, each player would get $10. And that $10 actually in 2023 would be the equivalent of close to $307. That was a lot of money back in 1909. This also has to do with the 1909 Copyright Act. Again, there's a right of privacy that is instituted in this 1909 Copyright Act. I actually read the Copyright Act, and it is not good discussion on a first date with a lady. Let me tell you, you will not get a second. So there were lawsuits from the beginning in 1909 and 1910, and one of those lawsuits was a Olympian, a gold medal Olympian named Harry Porter, and he is found in the T218 set. This kind of brings me up to another point that I found in the terms and conditions, or the contract, if you will, of both Fanatics and Topps, where it says any image or images of a person who has current or remaining collegiate athletic eligibility, you can't basically make money off of, or these people cannot make money off of their images on a website like Topps or whatever. That I understand too. And then Harry Potter, he was a gold medal Olympian, and I believe it was London in 1908. Was He was banned from participating further. Maybe took $10, which for an amateur you can't do. And so he sued the American Lithograph Company in 1910, and he said that the company didn't have permission to use his likeness. Now you see the card, and you're like, that could be anybody, but it does specifically state Harry Potter's name. He lost. What's kind of interesting about this too is that Honus Wagner, when he found his face, his likeness on a card, he threatened to sue the American Lithograph Company, or American Tobacco Company. So the story goes. There's actually, I think, three different explanations that I've heard, and we're not entirely sure what the truth actually is on this thing with the T206 Wagner. One of the stories goes from hobby pioneer John D. Wagner, was that Honus Wagner didn't like kids to smoke, and I understand that. It's really interesting because people say that, Honus Wagner is found on a leaf card from 1948 with a package of chew, right? So he did smoke himself. He just didn't want other kids to smoke. And at the time, you had a lot of kids who were working at the American Tobacco Company and smoking. And one of the theories is that the American Tobacco Company produced a lot of new young smokers through their cards. And I don't have any doubt that that actually happened. But the other really interesting case, I think, is Francis Ouimet. And Francis Ouimet is a really interesting amateur golfer. He won the 1913 U.S. Open. He was a teenager when he did it, and he became a very successful businessman. However, early in his career as a amateur, he was banned from golf uh, because he opened a pro shop, and they banned him. I think while he was overseas in France fighting in World War I, they lifted the ban. You don't really have a whole lot of cards from Francis Ouimet. Nothing from like 1913, 1914. He does have a 1926 Spalding Champions, which is a bucket list card for me, and he has a few others. I think a Churchman from 1931 or 1928. So he's got very little in the way of cards. The other one is Babe Diedrichson. Again, I did a video on her. She doesn't really have a whole lot of cards. A few things in Germany from like 1932, but for the most part, the 1933 Gaudi Sport King is what she's on. She may have a few things here and there, but she did actually try to sue a company for using her likeness in an advertisement. I think that was in 1931 or 1932. And again, she has a 1933 Gaudi. She again was banned from participating in any kind of athletic events. She had amateur status, which she broke apparently when they claimed that she had signed a contract for money in this advertisement to sell cars. I'm not entirely sure or convinced exactly what the entire truth is. Did she? Did she not? But she's again someone who doesn't have a whole lot of cards. Johnny Mize also doesn't have a lot of cards from like 1936 to 1941. He's really only found on one card, and that's the 1936 National Chicle Pastel. And you don't see him in another card until 1941 with the, I think it's a W754 or W753. That's the St. Louis Cardinals team issue. It's a really neat set, by the way, if you guys haven't seen one of those. They kind of look like 1948 Bowmans in a way, but a higher quality. So he's got one of those, and then he's got cards after World War II. Again, Johnny Myers did lose his case, and I did I think a fairly decent job of explaining why that was. It's one of my favorite articles. I also found something that was really interesting here that came up too, and I wanted to kind of read this to you guys. This is number 8. It says products purchased through an account are for distribution through the stores identified in the account information attached hereto only. For clarity, products are for resale to directly consumers in a physical retail brick-mortar environment only in the product's original unopened form, i.e., no business to business or online sales unless otherwise agreed by Topps in writing. Retailers shall not use its account for personal shopping, and products shall not be used for repacks unless authorized in writing in advance. I haven't actually seen the rest of that, so I don't know if it pertains to something a little more specific, but that really kind of gets underneath my fingernails here, and I'll tell you why. Once you, as the consumer, buy a product, it is then yours to do what you will with it. I kind of think that that may be a direct violation of the Clayton Act of 1914, as I just as specifically stated earlier in Section 3. That is something that the Federal Trade Commission will have to look at, and the Federal Trade Commission actually has um, a, a, a very interesting history when it comes to the hobby. They looked into the first Flair versus Topps case in 1962, and there's a really interesting report. It's quite lengthy, in fact, on this whether or not Flair or Topps, I should say, had a monopoly, which prevented Flair from entering, and it was contract based, in fact, on contracts for ball players. The most contracts was by Bowman, and then once Topps bought Bowman in February of 1956, Topps ended up grabbing all the contracts, and they were able to get contracts from minor leaguers as well, or players just coming up. And so that's how Topps was able to become a monopoly as well, because of their player contracts. Clarence Newcomer did look at that as well, and from the standpoint of a judge, he actually was very astute to the hobby. He really was. This is really kind of unusual because, again, you don't have a whole lot of judges and courts and juries that know a whole lot about sports cards. At least you didn't in the past. And that was really the roadblock to a lot of the court cases between, say, Bowman and Topps, or Flair or Don Russ, is because not only did the courts not understand the technology, but they saw the hobby as just that, a hobby for kids, and not a business, as, say, what Great Britain, the tobacco companies in Great Britain saw the hobby as. Sports cards were not the main product. They were issued with gum, which was the main product, or whatever else, right? So they could in fact say, like, contracts aside, with these players, we're actually selling chewing gum, and not the sports card. 9 times out of 10, they would lose their case, the ball players in court. And in the 1950s, you had a series of these quote unquote contract wars, which I think started in about 1947, 1948, with Leaf and Bowman, and then with Topps, and they ended in 1953 with Judge Jerome Frank, and that's a fascinating case too. So one of the concerns I think that the small businesses have here, or the shop owners have, in believing that this could easily turn into a monopoly, or is essentially a restraint of trade, is, well, first it's two things. You have to agree and abide by these terms and conditions, and that the company could cut you off at any time for any reason whatsoever. In fact, they don't have to have a reason to not supply the small business owner with product. And if Fanatics and or Topps, both of these companies, if they have all of the licenses, then that could actually that could do harm to any business that wants to get into producing sports cards. They could probably still produce sports cards, they just wouldn't be licensed. These licenses that they have one for the NBA, one for Major League Baseball, the NFL, NASCAR, NHL, Major League Soccer, Formula One. They also own Topps, as I said. They own Point Bet. That could be a problem too, depending on whether or not betting is legal in your state. And then I believe they also own PWCC. Personally, I wouldn't touch PWCC with a 10-foot pole. That's just me. I don't like what I've heard from PWCC in the past, and that really needs to be cleared up by the FBI. I think I'd love to hear what the FBI has to say about PWCC and Beckett, and all those other companies with the connection to the grading scandal, and the autograph forgery scandal as well. So I'd love to see what they have to say before I start doing any business with PWCC. And then again, you have Golden Auctions as well, um, and that is a collector's universe, but it's all connected here. So I want to hear what you guys have to say about this. If you think that this could be a potential for a monopoly, is it a monopoly already? Is it a violation of the Clayton Act of 1914? Does this harm small businesses? And the way they do business. I think for me personally, if I own a small business like this, a card shop, to have another business essentially being a regulatory agency, which what it looks like, I would tell them to go fly a kite. My financial business and how many people I employ is my business, and really the federal government's or the state government's, not another business, which I think could be a direct competitor to me if I decide to become like Upper Deck, right? So Upper Deck was, I think, a card shop that turned into a business selling sports cards. uh, Again, I think a lot of that stuff is quite private to the small business, and there's probably more than enough reasons why that small business would not want to share their financial information to a company that could be a competitor, or at least put them out of business. I don't see that any company that goes into another company and says, we don't like the way you're doing business, so we're going to shut off products, your access to products. I think that's I don't think that's right at all. I think it's very dangerous to business. In fact, I think it's dangerous to us, the consumer, and I don't think that they have a right to do that. Morally, I don't think it's the right thing to do. Are there small businesses or local card shops that should clean up their act? Probably. You know, business is tough enough as it is. It used to be that prior to 1960, your average lifespan of a business was 50 years. Today, it's about 20 years. A lot of businesses usually don't make it out of their first year of business. And by year five, if they make it that long, they'll probably make it to 10 years. But as I said, most businesses don't last 20 to 25 years. That's usually the max for every business, any business today. So you have that. Then you have the internet and all this other stuff, and they kind of like, the bad ones weed themselves out naturally. The one thing I really want to know, and this really kind of seems to be really out of the pages of this book right here, is that um, back in 1906, 1907, and 1908, it was found that there were certain tobacco companies that were secretly held by the American Tobacco Company, and the American Tobacco Company didn't tell anybody who the actual owner was. Now, in this case with Fanatics, they own a lot of properties already, but are they kind of like, or tops telling small businesses that these small businesses, the local card shops, are now subsidiaries of Fanatics secretly? I'm not sure. It kind of seems like that in a way. The similarities here between American Tobacco Company and now what's going on here is really very close. Again, I want to hear what you guys have to say about this. Maybe there's something I'm missing, or again, maybe you agree with me. I have no idea. And if you disagree, that's great. That's fine. Again, I don't have any real skin in the game on this because I am not a modern collector, but I am a collector, and I want to make sure everything is on the up and up here and not harming consumers or small businesses and uh, card shops. And small businesses have already taken a huge hit with the pandemic and the lockdowns over the last couple of years, and the economy really hasn't come back. And for a lot of locations, local card shops, um, they do feed the local economy and the areas in which they're around. So I don't want to lose them altogether. So again, guys, and thank you so much for stopping by. I greatly appreciate it as always. Let me know what you think in the comments below. Keep them civil too. But I will talk to you later and have a good one. Bye.